We back rights and liabilities of mortgagee. Rights and liabilities of mortgagee. 67. Right to foreclosure or sale. In the absence of a contract to the contrary, the mortgagee has at any time after the mortgage money has become due to him and before a decree has been made for the redemption of the mortgage property, or the mortgage money has been paid or deposited as hereinafter provided, a right to obtain from the court a decree that the mortgagor shall be absolutely debarred of his right to redeem the property, or a decree that the property be sold. A suit to obtain a decree that the mortgagor shall be absolutely debarred of his right to redeem the mortgage property is called a suit for foreclosure. Nothing in this section shall be deemed A. to authorize any mortgagee other than a mortgagee by conditional sale, or a mortgagee under anonymous mortgage by the terms of which he is entitled to foreclose, to institute a suit for foreclosure, or a usufructory mortgage as such, or a mortgagee by conditional sale as such, to institute a suit for sale, or B. to authorize a mortgagor who holds the mortgagee's right as his trustee or legal representative, and who may sue for a sale of the property, to institute a suit for foreclosure. Or, I don't know if I did, so I'm going to read B. to authorize the mortgagor who holds the mortgagee's rights to his trustee or legal representative, and who may sue for a sale of the property, to institute a suit for foreclosure. Or C. to authorize the mortgagee of a railway, canal, or other work in the maintenance of which the public are interested, to institute a suit for foreclosure or sale. Or D. to authorize a person interested in part only of the mortgage money to institute a suit relating only to the corresponding part of the mortgage property, unless the mortgagee have, with the consent of the mortgagor, severed their interests under the mortgage. 67A. Mortgagee, when bound to bring one suit on several mortgages. A mortgagee who holds two or more mortgages executed by the same mortgagor, in respect of each of which he has a right to obtain the same kind of decree under section 67, and who sues to obtain such decree on any one of the mortgages, shall, in the absence of a contract to the contrary, be bound to sue on all the mortgages in respect of which the mortgage money has become due. Wow. 68. Right to sue for mortgage money. 1. The mortgagee has a right to sue for the mortgage money in the following cases, and no others, namely: A. where the mortgagor binds himself to repay the same. B. where by any cause other than the wrongful act or default of the mortgagor or mortgagee, the mortgage property is wholly or partly destroyed, or the security is rendered insufficient within the meaning of section 66, and the mortgagee has given the mortgagor a reasonable opportunity of providing further security, either security enough to render the whole security sufficient, and the mortgagor has failed to do so. Okay. C. where the mortgagee is deprived of the whole or part of his security by or in consequence of the wrongful act or default of the mortgagor. D, where the mortgagee being entitled, where the mortgagee being entitled to possess of the mortgage property, the mortgagor failed to deliver the same to him or to secure the possession thereof to him without disturbance by the mortgagor or any person claiming under a title superior to that of the mortgagor, provided that in the case referred to in clause A, a transferee from the mortgagor or from his legal representative shall not be liable to be sued for the mortgage money. 2, where a suit is brought under clause A or clause B of subsection 1, the court may, at its discretion, stay the suit and all proceedings therein, notwithstanding the contract to the contrary, until the mortgagee has exhausted all his available remedies against the mortgage property and what remains of it, unless the mortgagee abandons his security and, if necessary, retransfer the mortgage property. 69, power of sale when valid. 1, a mortgagee or any person acting on his behalf shall, subject to the provisions of this section, have power to sell or concur in selling the mortgage property or any part thereof in default of payment of the mortgage money without the intervention of the court in the following cases and in no other, namely: A, where the mortgage is an English mortgage and neither the mortgagor nor the mortgagee is a Hindu, Mohammedan, or Buddhist, or a member of any other race, sect, tribe, or class from time to time specified in this behalf by the state government in the official gazette. B, where a power of sale without the intervention of the court is expressly conferred on the mortgagee by the mortgage deed and the mortgagee is the government. C, where a power of sale without the intervention of the court is expressly conferred on the mortgagee by the mortgage deed and the mortgage property or any part thereof was on the date of the execution of the mortgage deed situate within the towns of Calcutta, Madrid, Bombay, or in any other town or area which the state government may, by notification in the official gazette, specify in this behalf. 2, no such power shall be exercised unless and until a notice in writing requiring payment of the principal money has been served on the mortgagor or one of several mortgagors and default has been made in payment of the principal money or of part thereof for 3 months after such service, or B, some interest under the mortgage amounting at least to 500 rupees is in arrear and unpaid for 3 months after becoming due. 3, when a sale has become made in professed exercise of such a power, the title of the purchaser shall not be impeachable on the ground that in no case had arisen to authorize the sale, or that due notice was not given, or that the power was otherwise improperly or irregularly exercised, but any person damnified by an unauthorized or improper or irregular exercise of the power shall have his remedy, in damages against the person exercising the power. 4. The money which is received by the mortgagee arising from the sale after discharge of prior encumbrances, if any. Come back and read 4. The money which is received by the mortgagee arising from the sale after discharge of prior encumbrances, if any, to which the sale is not made subject, or after payment into court under Section 57 of a sum to meet any prior encumbrance, shall, in the absence of a contract to the contrary, be held by him in trust to be occupied by him, first, in payment of all costs, charges, and expenses properly incurred by him and incident to the sale or any attempted sale. Secondly, discharge of the mortgage money and costs and other money, if any, due under the mortgage, and the residue of the money so received shall be paid to the person entitled to the mortgage property or authorized to give receipts for the proceeds of the sale thereof. Nothing in this section or in Section 69A applies to powers conferred before the first day of July 1882. 69A, appointment of receiver. 1. A mortgagee have the right to exercise a power of sale under Section 69 shall, subject to the provisions of subsection 2, be entitled to appoint by writing, signing by him or on his behalf, a receiver of the income of the mortgage property or any part thereof. 2. Any person who has been named in the mortgage deed and is willing and able to act as receiver may be appointed by the mortgagee. If no person has been so named, or if all persons named are unable or unwilling to act or are dead, the mortgagee may appoint any person to whose appointment the mortgagor agrees. Failing such agreement, the mortgagee shall be entitled to apply to the court for the appointment of a receiver, and any person appointed by the court shall be deemed to have been duly appointed by the mortgagee. A receiver may at any time be removed by writing, signed by or on behalf of the mortgagee or the mortgagor, or by the court on application made by either party or on due cause shown. A vacancy in the office of receiver may be filed in accordance with the provisions of this subsection. 3. A receiver appointed under the powers conferred by this section shall be deemed to be the agent of the mortgagor, and the mortgagor shall be solely responsible for the receiver's acts and defaults, unless the mortgage deed otherwise provides, or unless such acts or defaults are due to the improper intervention of the mortgagee. 4. The receiver shall have power to demand and recover all the income of which he is appointed receiver by suit, execution, or otherwise in the name either of the mortgagor or of the mortgagee, to the full extent of the interest which the mortgagor could dispose of, and to give valid receipts accordingly for the same, and to exercise any powers which may have been delegated to him by the mortgagee in accordance with the provisions of this section. 5. A person paying money to the receiver shall not be concerned to inquire if the appointment of the receiver was valid or not. 6. The receiver shall be entitled to retain out of any money received by him for his remuneration and in satisfaction of all costs, charges, and expenses incurred by him as receiver, a commission at such rate not exceeding 5% on the gross amount of all money received as is specified in his appointment, and if no rate is so specified, then at the rate of 5% on that gross amount, or at such other rate as the court thinks fit to allow on application made by him for that purpose. 7. The receiver shall, if so directed in writing by the mortgagee, insure to the extent, if any, to which the mortgagee might have insured, and keep insured against loss or damage by fire out of the money received by him, the mortgage property, or any part thereof being of an insurable nature. 8. Subject to the provisions of this act as to the application of insurance money, the receiver shall apply all money received by him as follows, namely, 1 or I, in discharge of all rents, taxes, land revenue, rates, and outgoings, whatever affecting the mortgage property. 2, in keeping down all annual sums and other payments and the interest on all principal sums having priority to the mortgage in right thereof, he is receiver. 3, in in payment of his commission and of the premiums on fire, life, and other insurance, if any, properly payable under the mortgage deed or under this act, and the cost of executing necessary or proper repairs directed in writing by the mortgagee. 4, in payment of the interest falling due under the mortgage. In payment of the interest falling due under the mortgage. 5, in or towards discharge of the principal money, if so directed in writing by the mortgagee, and shall pay the residue, if any, of the money received by him to the person who, but for the possession of the receiver, would have been entitled to receive the income of which he is appointed receiver, or who is otherwise entitled to the mortgage property. 9. The provisions of subsection 1 apply only if and as so far as a contrary intention is not expressed in the mortgage deed, and the provisions of subsection 3 to 8 inclusive may be varied or extended by the mortgage deed, and as so varied or extended shall, as far as may be, operate in like manner and with all the kind incidents, effects, and consequences as if such variations or extensions were contained in the said subsections. 10. Application may be made without the institution of a suit to the court for its opinion, advice, or direction on any present question respecting the management or administration of the mortgage property, other than questions of difficulty or importance not proper in the opinion of the court for summary disposal. A court of such applications shall be served upon, and the hearing thereof may be attended by such of the person interested in the application as the court may think fit. The cost of every application under this subsection shall be in the discretion of the court. 11. In this section, the court means the court which would have jurisdiction in suit to enforce the mortgage. 70. Accession to mortgage property. If after the date of a mortgage, any accession is made to the mortgage property, the mortgagee, in the absence of a contract to the contrary, shall, for the purposes of the security, be entitled to such accessions. Illustrations. A mortgages to be a certain field bordering on a river. The field is increased by alluvion. For the purposes of his security, B is entitled to the increase. B, a mortgage a certain plot of building land to B, and afterwards erects a house on the plot. For the purposes of his security, B is entitled to the house as well as the plot. 71. Renewal of mortgage lease. When the mortgage property is a lease and the mortgager obtains a renewal of the lease, the mortgagee, in the absence of a contract to the contrary, shall, for the purposes of the security, be entitled to the new lease. 72. Rights of mortgagee in possession. A mortgagee may spend such money as is necessary. B, for the preservation of the mortgage property from destruction, forfeiture, or sale. C, for supporting the mortgagor's title to the property. D, for making his own title thereto good against the mortgagor. And E, when the mortgage property is a renewable leasehold, for the renewal of the lease, and may, in the absence of a contract to the contrary, add such money to the principal money at the rate of interest payable on the principal, and where no such rate is fixed, at the rate of 9% per annum, provided that the expenditure of money by the mortgagee under Clause B or Clause C shall not be deemed to be necessary unless the mortgager has been called upon and has failed to take proper and timely steps to preserve the property or to support the title. Where the property is by its nature insurable, the mortgagee may also, in the absence of a contract to the contrary, insure and keep insured against loss or damage by fire the whole or any part of such property, and the premiums paid for any such insurance shall be added to the principal money when with interest at the same rate as is payable on the principal money, or where no such rate is fixed at a rate of 9% per annum, but the amount of such insurance shall not exceed the amount specified in this behalf, or in the mortgage deed, or if no such amount is therein specified, 2/3 of the amount that would be required in case of total destruction to reinstate the property insured. Nothing in this section shall be deemed to authorize the mortgagee to insure when an insurance of the property is kept up by or on behalf of the mortgagor to the amount in which the mortgagee is hereby authorized to insure. 73. Right to proceeds of revenue sales or compensation on acquisition. 1. Where the mortgage property or any part thereof or any interest therein is sold owing to failure to pay arrears of revenue or other charges of a public nature or rent due in respect of such property, and such failure did not arise from any default of the mortgage and the mortgagee shall be entitled to claim payment of the mortgage money in whole or in part out of any surplus of the sale proceedings remaining after payment of the arrears and of all charges and deductions directed by law. 2. Where the mortgage property or any part thereof or any interest therein is acquired under the Land Acquisition Act 1894, 1 of 1894, or any other enactment for the time being in force provided for the compulsory acquisition of immovable property, the mortgagee shall be entitled to claim payment of the mortgage money in whole or in part out of the amount due to the mortgagor as compensation. 3. Such claims shall prevail against all other claims except those of prior encumbrances, and may be enforced notwithstanding that the principal of money on the mortgage has not become due. 74. Right of subsequent mortgagee to pay off prior mortgagee, rep by the Transfer of Property Amendment Act 1929, 20 of 1929, S39. 75. Rights of Mincy mortgagee against the subsequent mortgagees, rep by S39 IBIT. 76. It's probably the last one. 76. Liabilities of mortgagee in possession. When, during the continuance of the mortgagee takes possession of the mortgage property, A, he must manage the property as a person of ordinary prudence would manage it if it were his own. B, he must use his best endeavors to collect the rents and profits thereof. C, he must, in the absence of a contract to the contrary, out of the income of the property, pay the government revenue all other charges of the public nature and all rent accruing due in respect thereof during such possession, and any arrears of rent in default of payment of which the property may be summarily sold. D, he must, in the absence of a contract to the contrary, make such necessary repairs of the property as he can pay for out of the rents and profits thereof, after deducting from such rents and profits the payment mentioned in clause C and the interest on the principal money. E, he must not commit any act which is destructive or permanently injurious to the property. F, where he has insured the whole or any part of the property against loss or damage by fire, he must, in case of such loss or damage, apply any money which he actually receives under the policy, or so much thereof as may be necessary in reinstating the property, or if the mortgagor so directs, in reduction or discharge of the mortgage money. G, he must keep clear, full, and accurate accounts of all sums received and spent by him as mortgagee, and at any time during the continuance of the mortgage, give the mortgagor, at his request and cost, true copies of such accounts and of the vouchers by which they are supported. H, his receipts from the from the mortgaged property, or where such property is personally occupied by him, a fair occupation rent in respect thereof shall, after deducting the expenses properly incurred for the management of the property and the collection of rents and profits and other expenses mentioned in clauses C and D, and interest thereon, be debited against him in reduction of the amount, if any, from time to time due to him on account of interest, and so far as such receipts exceed any interest due in reduction or discharge of the mortgage money, the surplus of any shall be paid to the mortgagor. When the mortgagor tenders or deposits in manner hereinafter provided the amount for the time being due on the mortgagee must, notwithstanding the provisions in the other clauses of this section, account for his receipts from the mortgage property from the date of the tender or from the earliest time when he could take such amount out of court, as the case may be, and shall not be entitled to deduct any amount therefrom on account of any expenses occurred after such date or time in connection with the mortgage property. All right, so we're gonna go to here, and then we're gonna have to come back on priority because I don't have no more juice, man. Loss occasioned by his default. If the mortgagee fails to perform any of the duties imposed upon him by this section, he may, when accounts are taken in pursuance of a decree made under this chapter, be debited with the loss, if any, occasioned by such failure. 77. Receipts in lieu of interest. Nothing in section 76, clause B, D, G, and H applies to cases where there is a contract between the mortgagee and the mortgagor that the receipts from the mortgage property shall, so long as the mortgagee is in possession of the property, be taken in lieu of interest on the property of the principal money, and in lieu of such interest and defined portions of the principal. So whenever we gonna come back, it's gonna be under priority 78. Priority 78. Peace, everyone.